for trainings like this. So I'd love to introduce our trainer today. We have Eli Nunez, one of our awesome HR directors who you may have the pleasure of working with if you call into that complimentary HR hotline. So you are in great hands. Good morning. Excuse me. Good morning, Eli.
Good morning, Anna. Thank you very much for that great introduction. And thank you to the Alameda County Workforce Development Board for sponsoring this, for having us on and giving us a chance to present to you. As a reminder, Anna mentioned that hotline for employers free for you in Alameda County, brought to you by the Workforce Development Board. If you have any HR related questions, questions about this presentation, questions about whatever it is, whether it's a leave of absence, whether it's FMLA, whether it's about breaks, overtime, anything HR personnel related, you can call that number 888-202-5668, Monday through Friday from 8 a.m. to 5 p.m. And we are there to help. Again, even if it's a situation where you're not sure if it's an HR related, you just kind of have a personnel thing going on, you want to talk about it, give us a call. We're a sympathetic ear for that as well. And speaking of us, a little bit more about our organization. We are California Employers Organization, and we like to say that we keep the human in human resources. In other words, we provide employer support with any type of HR topics. We know it's very complicated, especially in the state of California. So we are there as a resource for you to help you, one, navigate through those difficult situations, and two, be able to focus your attention on other work-related things, other, employment issues or business issues or whatever it is. Whether it's you're an HR professional or just a manager or owner that's doing HR functions, we want to bring you peace of mind through our support, whether it's on that hotline or presentations such as this that you are on today. And with that, if you're wondering, well, should I call? Are they going to know what we're talking about? We do have several members in a lot of different industries, as you can see from the slide here, everything from insurance to food manufacturing to restaurants to hospitality, whatever it is. So chances are, if you have a situation or a question that you think is a little weird, you're not going to shock us. We may have heard it before, heard something similar, and if we haven't, there's probably over a century of experience between all our team here in different aspects of HR. So we are here and ready to help. One thing I would like to point out, though, is that we are not lawyers. We're not a legal organization or a lawyer law firm. And even though we do have people on our team with legal experience, we do not provide legal advice. If you have a question that's of a legal nature, maybe we'll advise you to consult with legal counsel or, get an attorney because they'll be better able to advise you in that situation and provide you with guidance about your risks and better strategies in that aspect. So even though in this presentation we'll talk about some laws and some regulations, that sort of thing, we are not giving legal advice. It's more of an educational perspective or an educational basis. So with that, let's jump right into what we will be covering today. As you know, you're here for the top 10 ways to stay out of court. We've identified these through our research and through our many calls and questions that we get. So we've narrowed it down to these 10, and some of the areas that they'll cover, the first one will be starting and ending employment relationships effectively. That is, if you do things right from the beginning all the way through the end of the employment life cycle, or avoid some common pitfalls we're talking about, that goes a long way in keeping you out of court. Policies are very important. Setting those expectations, keeping your handbook current and compliant is very important as well as meal and rest breaks, timekeeping, employment misclassification, those sorts of things. Those are honestly tend to be low-hanging fruit for attorneys when it comes time to look for filing some kind of claim or some kind of lawsuit against employers. So we'll talk about those as well. And of course, harassment, right? Not just how you deal with harassment in the workplace, but also how you go about preventing it or preventing it from becoming a big issue. So our top 10 countdown kind of fall and cover into all these areas. So let's go ahead and get started with number 10. And what we've identified as the number 10 way to stay out of court is make sure you have strong hiring practices. Now, around here in CEA, you may have heard us say before, we have a little saying that says hire slow, fire fast, right? So let's talk about the hire slow part. That means when you're going to hire somebody or you have an opening in your organization, take your time, know what the job description is. If it's a new position, create a job description and you'll determine what you need. Don't rush into it. A lot of times we think we have to just throw a body under it to keep moving. In this situation, this is where you want to do your homework, right? You don't want to rush into a situation. You want to make sure that you hire the right person. And the thing to keep in mind too is California has a lot of restrictions when it comes to hiring and interviewing people that are not present in other states. So you want to make sure you know what those are so you don't have a misstep right at the very beginning, right? Another thing to keep in mind too is that when you're onboarding somebody or doing an orientation for a new hire, that's really goes a long way in setting the tone for their career with you. So make sure that you don't just rush through that orientation or see it as just, paper pushing situation where you're just checking boxes and getting signatures and moving on. Make sure you're really investing in that new hire orientation and really using it again to set the tone and set those expectations for your employees. That's not saying that, you can ignore the paperwork, of course, because there are some required documents in the state of California. So you want to make sure that you get all those completed in the right time frames, right? And I mean, there's a laundry list of documents that you need in the state of California, and some of them even federally, right? Your I-9 form, you have to make sure that you get that filled up within 3 days. You want to make sure your employee fills out their tax forms, like the W-4 for federal taxes and the DE-4, and you want to make sure you have acknowledgments of certain policies, right? So if you have a harassment policy or any kind of policy that's important for your company, you want the employee to sign some kind of acknowledgement saying they received it, they understand it, and they agree to abide by it. That way in case you do have to do something in the future, you have that proven that the employee understood what was required of them and what the consequences were for failure to do so. Now, I did mention some different regulations present in California when it comes time to interview or hire people. And there are some laws that prohibit certain things or certain questions about being asked of our candidates or new hires for that matter. So the first one is, asking people's age. You cannot ask, or you should not ask that of a candidate during an interview, right? Same with family status or any kind of protected classification, ethnicity, sexual orientation, marital status, that sort of thing. Those are big no-nos during the interview process. Um, and even if you just do it conversationally, if that interview outcome is not what the candidate desired, they could very well use that and say, hey, you know what? They were asking me about my age or about my race or about whether I was married or not. And I think that's the reason why they didn't hire me. I think they discriminated against me. Even if you were just being conversational or friendly, if that comes up, that is something that that candidate that was turned down can hang on to and claim was the reason for their denial. So be very careful about touching on those topics, whether it's in an interview question or just in friendly conversation with that candidate before, during, or after the interview. The state of California also prohibits asking about salary history. So as you may recall, in the past, applications used to ask employees, where did you work and how much were you paid there? Well, that question is no longer and should no longer be present in applications. Reason for that is, California is a big proponent of equal pay across the board, right? And historically, there's been certain groups or certain genders that were paid less than others. So if we base our compensation decisions based on that on the person's historical income or historical compensation, it's going to continue to perpetuate that those two levels, right? Because there's not going to be a chance to catch up. So what we're looking for is, you're not going to ask about somebody's salary history, what they made at their last job. You can ask about their expectations, what range they want to be in, what they expect to be paid, but you cannot directly ask them what were they paid at their last job. If they volunteered of their own accord, hey, so be it. But again, our decisions shouldn't be based on that salary history. They should be based on the position and on our own practices. The other thing we cannot ask about is about criminal history until after we make a conditional job offer. So it's perfectly fine to do a background check as part of the job offer. And a lot of times if you create job offer letters, you'll see the language that says, we're offering this position contingent on successfully completing a background check and the drug screen or whatever else you require, right? So again, you cannot disqualify a candidate because of their criminal history, but you can disqualify a potential hire once you make that job offer. So again, we do not want to ask about criminal history until after we make that conditional job offer. So you don't want to ask about it during the interview when somebody walks in to ask for an application. any of those situations. We're going to wait until we make that job offer. So what that comes down to is, when you're interviewing or asking of anything of candidates, you're going to focus on questions about the job and how well the applicant can perform it. Their training, their, history, background, that sort of thing regarding the job. That is it. All right, let's move on to number 9, and that is the many leave laws in California. So, as of last count, California has more than 20 leave laws that offer protected leave for employees, and each one of them, of course, is different, right? They don't all have the same requirements or the same protections. They're all a little different, so it's important to know all of them and to know which ones apply to you. See, just because there's more than 20 doesn't mean you have to worry about all 20, because California puts different tiers on them. Some of them apply to all employers, some of them only apply to you if you have 5 or more employees, 15 or more employees, 16 or more employees, 25 or more, 50 or more, etc., etc. So it's important to know which of these apply to you. And one of the ones that we still get a lot of questions on the hotline and from our members or anyone we talk to is about paid sick leave, because that's one, it covers all employers in the state of California, and it can be a little complicated. So let's talk about sick leave a little bit here. The thing to know is that the state of California requires that you provide a minimum of 5 days or 40 hours of paid sick leave for your employees, whichever is more. You may ask yourself, well, 5 days or 40 hours, that's the same thing, isn't it? Not necessarily, because if you have part-time employees that work 4 hours a day, if you only give them 5 days, 5 of those 4 hour days, it only comes up to 20 hours, and that will not meet the minimum. So if you have part-time employees, you have to provide them with those 40 hours. Now, that doesn't mean you have to give them those 40 hours right off the bat. You do have a couple different choices in how you award that paid sick leave. You can either do it by accrual, where it's accrued at the rate of 1 hour for every 30 hours worked, or you can do a lump sum where you give those 5 days and or 40 hours all at the same time. And you can mix and match it as well. You can say, you know what? My full-time employees are going to get the lump sum, but my part-time employees are going to have to accrue. And even if they don't accrue the full 40 hours during the course of the year, as long as you're awarding them 1 hour for every 30 hours worked, you are compliant with California law. So keep that in mind. You can have a couple different, you can mix and match them depending on your employees and those positions, as long as you are not being discriminatory with it. In other words, as long as you're not saying, well, women are going to get a lump sum and men are going to have to accrue. You can say part-time and full-time is perfectly fine, but distinguishing people by protected characteristic is not okay. You can also have a waiting period before an employee uses that paid sick leave. So you can say, new hires cannot use paid sick leave until after their 90th day. And also, paid sick leave is not something that you pay out upon termination. So if an employee has, 40 hours of paid sick leave and they quit, they are not entitled to have that paid out unless you combine sick leave and vacation into a single PTO bucket, in which case you would have to. So we always say, be careful if you combine vacation and sick leave into PTO, because all the protections of sick leave and all the protections of vacation apply at that point. Something else to keep in mind too is in the state of California, different cities or different counties can establish different requirements for paid sick leave as long as they go above and beyond what the state requires. So there's certain cities, I know, being in Alameda, the Bay Area has some more protections for employees sometimes, more restrictions for employers. So be aware of where your employees are working, if they're remote, or if you send employees to travel out to other cities or other locations. For instance, if you're based in, somewhere in Alameda and you send employees out to San Francisco to work, be aware that there may be additional protections or additional requirements for employees performing work there. All right, let's move on to number 8, and that has to do with employee classification. In other words, making sure that our exempt employees that are paid on a salary basis really are exempt employees. I think we've all had a situation where an employee comes into our office, at least, sometime during our career, and if you haven't yet, it's going to happen, believe me. Or an employee comes in and says, hey, you know what? Why don't you just pay me salary? Don't pay me by the hour. And it sounds simple at first, right? You say, okay, well, I'll just pay you, this much per the week, regardless of work, and that's fine. Well, it's not that easy in the state of California. See, in order for us to have an exempt employee that's exempt from overtime and meal and rest breaks, they have to pass two requirements. They have to meet two requirements. The first one is they have to pass what's called the duties test. In other words, the majority of their job has to be spent doing something that's classified as exempt or that meets those requirements. And they also have to meet the salary requirement. In other words, they have to earn at least two times the state minimum wage, which is currently the equivalent of $70,304 per year. Now, in certain industries like fast food, that could be a little higher because the hourly minimum wage is higher, but generally in the state of California, that is our minimum requirement. A lot of questions we get asked as well, if I have an exempt employee, a manager that only works 3 days a week, can I pay them half of that? Nope. If they are going to be exempt from overtime and meal and rest breaks, they have to make at least $70,304 per year, regardless of what hours they work. Whether they work more than 40, less than 40, whatever it is, that is the minimum salary. Now, there are some commissioned employees, computer professionals and physicians that have a different salary test, so be aware of that. Their minimum salary may be a little bit higher. And the thing about exempt employees is, their compensation cannot be dependent on the hours or time that they work. We're paying them a flat salary for their skills, their knowledge, what they bring to the job, right? And what that means is that they're exempt from any kind of overtime laws, meal and rest breaks, timekeeping requirements, etc. They don't have to worry about punching a clock. They don't have to worry about, you don't have to worry about paying them overtime or about them taking their meal and rest breaks. Now, I talked about some of the meeting those duties tests, and these are the most common categories where people can be classified as exempt. We have the executives, in other words, your managers, the ones that manage the business or manage people. The administrative, the ones that, their work relates to management policies, such as your HR generalist, for example. And then we have professionals. Those are people that have to be licensed by the state of California. I'm thinking things like attorneys, some teachers, that sort of thing, right? They fall under that category. So these are the three most common ones. As we mentioned, there are other ones for computer professionals, for people in the medical field, that sort of thing. But these are the three most common ones. So remember, if you're going to classify somebody as exempt and pay them on a salary basis, they have to meet the duties test and the minimum salary requirement. All right, moving on to number 7. And that is following rules for non-exempt or hourly employees. So in the previous one, we talked about the exempt ones, the salaried employees. Now let's talk about your hourly employees. Now, non-exempt employees are paid by the hour for work they perform. In other words, you pay them minimum wage at least or above that for per hour. And the thing that's very important is they should not be performing any work for you off the clock. In other words, any work they perform for you has to be compensated, right? And that means that we have to track their time. So whether it's using an electronic time clock, whether it's a, old-fashioned time card where you punch the card, or whether, you have a digital clock or, biometric, whatever it is, we are tracking their working time and paying them accordingly. Now, non-exempt or hourly employees also mandatorily have certain breaks, lunches, and have to be paid overtime. And the thing to keep in mind is not all non-exempt hourly employees are the same. There are what are called wage orders that cover your employee based on what industry you are in. So if you don't know what your wage order is or you don't have that posted, give us a call. We could give you some resources on how to find out which wage order applies to you, because there are certain nuances or certain differences for both exempt and non-exempt employees depending on your industry. So again, be aware of that, what that is, and make sure you know how it applies to you so you can apply it correctly to your hourly employees. Now, speaking of those hourly employees, we want to make sure that we are complying with our minimum wage, whether it's the state minimum wage, or as I mentioned, in certain areas, there are minimum wages that are higher than that $16.90. And there are some increases here coming at mid-year. July 1st is usually when some municipalities, some cities, some counties, some different industries increase their minimum wage. We do have a resource for that. If you see that link, that bit.ly link there on the bottom right, we created a document that has all those different minimum wages throughout the state of California. So make sure that you check that out to see if it applies to you, or if you have employees that travel to other locations. That way you know if you have to be paying them a higher minimum wage for the work performed there. Now, there are also certain specific minimum wages for different industries like fast food and healthcare, so make sure you're aware of those. Those go beyond what the state minimum wage is, so make sure that you are aware of those. And again, if you have employees that travel or work remotely from different locations, make sure you're aware of the different local ordinances. As we said, there's over 40 of them. So follow that link, either that one that Anna so graciously dropped into the chat or that bit.ly link here on the page, and you can find out what those are. Because remember, that minimum wage is that you pay employees depends on where the employee is physically working. So if they're working from home remotely, you have to know what the minimum wage is there. If they're traveling for you, I always give the example of landscapers. If I have a landscaping company and I send employees out to Emeryville or to Oakland or to San Francisco, I have to know what the minimum wage is there to make sure I am paying them correctly. Now, our non-exempt employees are also allowed to take breaks, right? And how many breaks they have for the day is dependent on how many hours they're working, as you can see by this handy dandy chart we have there. And our duty as employers is not to police them to make sure they're taking those breaks, but only to authorize and permit them to take that 10-minute net break for every 4 hours worked. Now, there's no law that says it has to be exactly right in the middle of that 4 hours. So, in other words, once the 2 hour mark hits, they drop everything and take that break. But as close as possible or as close as practicable to those 4 hours, make sure we permit them and allow them or permit them and authorize them to take that break, right? Now, those rest breaks, those 10-minute rest breaks are paid, so there's no need for them to record on the time card or clock out. But it's important that, we don't restrict what employees do during those rest breaks, right? So if an employee decides, hey, you know what, it's my 10-minute break, I'm gonna, run 4 minutes up the road to the gas station and grab a coffee or a snack or whatever and then run back, that's perfectly fine. As long as they're back on time, you don't care where they go or what they do during that break. If they want to go out to their car and take a 10-minute nap, hey, that's on them. That is their time. And that's important because failure to provide an adequate rest break or an insufficient rest break, or if we interrupt it, will subject us to a 1 hour premium pay penalty. In other words, if you deny an employee a break or don't let them take it or cut it short, we owe them 1 hour of premium pay for that mistake, right? So be aware of that. And that same penalty also applies to meal breaks, right? So again, for meal breaks, same thing. We have to permit a minimum of 30-minute uninterrupted meal break if the employee is working more than 5 hours. If they work over 10 hours, they are entitled to a second meal break as well. Now, meal breaks are unpaid, so you do have them clock out for that. And make sure that that meal break starts before the fifth hour of the day. So they have to clock out by at least 4 hours and 59 minutes into their shift. Otherwise, it's a violation that could cost a 1 hour premium pay penalty. Something else to keep in mind too, and this is very important. This was a development that came about because of a court case. If you have electronic time clocks and you're using rounding, at the very least, make sure you are not rounding those meal breaks. Reason for that's very simple. Say, for instance, employee goes to take a meal break at 12 o'clock, but they don't clock out till 12:01. Time clock will round that back to noon. Seems innocent, right? They go to clock back in, they clock back at 12:28, and the time clock rounds it to 12:30. So on the surface, it looks like they got a half-hour break. However, realistically, since they clocked out at 12:01 and clocked back in at 12:28, that is only a 27-minute net meal break and is a violation of California law. So do not round your time, do not round time for lunches, and we recommend not rounding time at all if you have the capability to do so. So if you have a time clock that has the option of rounding, turn that off. Just pay them exactly to the minute. Again, you could have rules as to when employees can clock in and out so they don't clock in too early or clock out too late. So just, you know, don't bother with rounding because it can prove to be very problematic. Now, non-exempt employees are also entitled to overtime for any hours worked over 8 in a day and for any hours worked over 40 in the work week. This is where we differ a little bit from federal law. Federal law says you only have to pay overtime for any hours worked over 40. However, in the state of California, any hours worked over 8 are also entitled to time and a half. And if employees worked on the seventh consecutive workday of the work week, not 7 days in a row, but 7 days in your defined work week, the first 8 hours of that seventh day are paid at time and a half. California also has double time. Again, this is different from federal law. So for any hours worked over 12 in a regular workday, you have to pay double time. And if the employee works beyond 8 hours on that seventh consecutive day in the work week, any hours past 8 on that seventh day are also paid at double time. Now, overtime is based on the regular rate of pay and not the base hourly rate. And if you're confused by that, that's okay. You're not the only one, right? Because regular rate of pay can be higher than the base hourly rate. So, in other words, if I hire my employee and say I'm going to pay you $20 an hour, but then I also give them some type of non-discretionary bonus or they're on piece rate or commission or whatever, we have to factor those things in get their regular rate of pay or their real rate of pay, and that is what we use for their overtime. So if you don't use, if you don't give any non-discretionary bonuses, if you don't have piece rate, if you don't have commission, don't worry about that. Chances are it's going to be the same as the base hourly rate. But if you have any of those other kickers that kick in to compensate your employees a little more, then they could raise their, average hourly rate a little higher than what their base hourly pay is. So just keep that in mind, right? And again, if you do pay any kind of bonuses or that sort of thing, and you're not sure if they apply or if they're going to affect that regular rate of pay, give us a call. We can talk through it. Now, a lot of times when we make any of these wage and hour mistakes, we could be subject to a PAGA claim. And PAGA is kind of like the boogeyman for employers, right? We hear those words and it's like, oh man, I'm in trouble now. Well, good news is, and if you're not familiar with PAGA, that's what's called the Paid Attorney General Act, which allows an employee or private attorney to step into the shoes of the state in order to bring a claim against an employer. So, in other words, this allows employers to make a claim without having to go through the state. This is very popular for wage and hour, meal and break, that sort of thing. So, again, now the state of California realized that, hey, employers are getting tattooed by these PAGA claims, right? I mean, it's costing a lot of money. So what we're going to do is give them a little relief by allowing a little bit of grace for them, right? It's not a complete forgiveness if you make a mistake. However, what the state says, if you're taking reasonable steps to try to comply with wage and hour laws, we're going to take that into account when it's time to penalize you, and we're going to lower those penalties a little bit, or we could potentially lower those penalties a little bit. And what some of these reasonable steps they identified are things like auditing your payroll on a regular basis and taking action when you find mistakes, having lawful written policies, training your supervisors, and, you know, if you're going to have those written policies and those trainings and somebody steps out of line, taking corrective action if the supervisor is not following your policies. So again, if you take those steps, you have those steps in place, and you do find yourself subject to a PAGA claim, those showing proof that you're taking these steps can help at least reduce those penalties a little bit. So keep that in mind. And if you do need help with that, we do offer a wage and hour audit package available at our store. If you need a hand auditing your wage and hour, your payroll, that sort of thing, to help to maybe minimize some of this damage in the future or prevent it from even being an issue for you. All right, enough about these non-exempt employees and exempt employees. Let's talk about number 6, which are independent contractors and misclassifying them. Again, this is another situation that we run across as HR practitioners and managers where we have employees that come to us and say, you know what? Just pay me as a contractor, pay me as a 1099 employee. That way I don't have to pay taxes. And it's like, oh, sounds like a win-win, right? Not so fast, because the state of California has very strict guidelines and what it takes to be classified as an independent contractor. We can't just say, I'm a contractor, pay me as a contractor, and that's it. Nope. State of California says if an employee is going to be classified as an independent contractor, they need to meet what's called the ABC test. They need to meet three parts or all three of these different sections of the test, right? The first one is they have to be free from control and direction of the hirer. In other words, if you hire a contractor, you hire them on a project basis. You don't hire them to manage them day to day like you do your employees. So if I hire a contractor because I need a new roof on my house, I'm not hiring them and telling them what to do step by step. I'm hiring them and telling them, okay, I'm going to pay you this much to put a roof on my house. I'm not going to tell you how to do it. I'm not going to tell you all the steps. I'm going to tell you what I want, but it's up to you to determine how you do it. Next one is they have to perform the work that is outside the usual course of the hiring entity's business. In other words, if I run a clothing factory, right, and I have a lot of people there sitting there on sewing machines, sewing shirts, sewing shirts, sewing shirts, and I hire somebody and I say, you know what, you are, you know, I'm going to hire you as an independent contractor because I need more help sewing these shirts, right? But I'm going to bring you in as a contractor on a project basis. You're going to do 50 shirts, and I'm going to pay you for those 50 shirts, even though the rest of my employees are paid by the hour. That is not going to work because the work that that contractor is going to be doing is going to be the same as what my regular employees are doing. So that would disqualify them from being an independent contractor. So I have to do something that's outside the usual course of our business, something that's not being done in our day to day or by people in our organization. And finally, they have to engage in the trade, occupation, or business of the same nature as the work performed. In other words, if I run an electrical company and I need help, I can't say, well, I'm going to hire this guy that's a plumber and have him do electrical work, but since he's a plumber, I'm going to pay him as a contractor. No. If you hire somebody as a plumber, they have to do plumbing work. If you hire an electrician, they have to do electrical work, right? That's what you're hiring them for. You can't just kind of fudge the facts based on their title. So again, for someone to be considered an independent contractor, they have to meet all three of those. And if you do have people on board right now that you're paying as contractors, but you're not sure if they are or not, this is one of those situations where you're going to want to consult legal counsel because they're going to tell you, one, what the damage is, unfortunately, and also two, the best way to remedy that so that you can minimize the damage. All right, we're halfway through our countdown here. Let's go on to number 5, which is making sure you insure your business. Now, there are certain things that we are required to have as employers in the state of California. First one of them is workers' compensation, of course. Failure to have workers' compensation insurance can open you up not only to possible penalties from the state of California, but in the event of an accident, injury, or a death at work, it's a sure way to bankrupt your business and possibly land you some jail time, right? So again, make sure you have workers' compensation insurance. And it's not just about signing up for it, finding somebody online or in the phone book, sending the application and forgetting about it. Just having proof that you have it, think that's good enough. You're paying for a service when you get workers' compensation insurance. You're paying for protection. You're paying for a partner. So make sure that you know who your carrier is, know what their process is, and if you have a claim with them, make sure that you're partnering with them, keep them abreast of what's going on in the workplace so they can help you manage that claim. And if you suspect fraud, let them know you suspect fraud. If the person's not following doctor's instructions, make sure you let them know the person's not following doctor's instructions. If the doctor's instructions don't seem to be helping the person, make sure you let them know, right? These are your partners. You're paying them for this. Don't just send them money just so you can have a certificate on your wall or on file and think that's good enough. Make the most of those services. There's also other insurances that you can have to protect your business, of course. There's what's called employment practice liability, which what it does is it protects your business from claims made by employees, former employees, or potential employees about discrimination, harassment, wrongful termination, and wage and hour claims. So again, this is just extra insurance if you're worried about these things, if you're worried about some kind of claim about discrimination or harassment or wage and hour, that sort of thing, you can contact a carrier and ask about employment practice liability. Um, and some employers do it because we hear about what's going on out there. We hear about these multi-million-dollar settlements, right? I was just reading yesterday about a popular restaurant here in Sacramento that just had to settle for, I think it's like $2.25 million or something like that for wage and hour claims that became a class action. So again, if you're a business and you can afford to do so, even if you can't, just take a look at what that kind of coverage would cost and see if it would benefit you as an organization. All right, on the home stretch now, let's move on to number 4, and that one is preventing and promptly correcting harassment in the workplace. Now, this is another big one, right? Another one where we see a lot of claims, and when we see the big claims, a lot of times they have to do with harassment. I mean, look at just what happened a few years ago, before COVID, we had the Me Too movement that was based a lot on harassment going on by very powerful people in workplaces, right? And again, that those were made the news because one, it's a huge issue that needed to be addressed, and two, the large settlements or sums of money that were spent either fighting the claims or paying out for the wrongdoing, right? So again, one of the best things we could do to prevent any kind of harassment in the workplace, make sure that you are providing that mandatory training for our employees. Now, state of California says if you have 5 or more employees, you have to provide 1 hour of training for your regular employees, 2 hours of training for every employee with managerial responsibilities, regardless of their job title, every 2 years, right? And there's also timelines for that. So, new hires have to receive training within 6 months of their hiring date, or if you promote somebody into a managerial position, they have to receive the managerial 2 hours of training within 6 months of that promotion. Now, if you're hiring seasonal employees, thinking, well, that's one way to get around it, right? I'll hire them on the seasonals, let them go before 6 months, not have to worry about it. Not so fast. If you are knowingly hiring a seasonal employee, they have to receive harassment training within 30 days or 100 hours worked, whichever comes first. So, best practice for this, since we're going to have to do this training anyways, not many people are going to get out of it unless you're only hiring somebody on for one day. Just make it a part of the onboarding process. You bring somebody on and sometime in the first week, make sure you schedule that 1 or 2 hours of training for them, depending on whether they're a regular employee or have managerial responsibilities or supervisory responsibilities. Just schedule it during orientation during that first week, get it done, get it out of the way. That way, if something happens, you have proof that you provided that training, right? Next thing you're going to do is any time that there's a complaint or allegation of harassment or discrimination or retaliation, you're going to investigate it pretty much as soon as you get that claim. Be prompt about it. The state of California says if an employer, in other words, an organization, knew or should have known that there was harassment or discrimination present in the workplace, they have the responsibility to address it immediately. Now, what do I mean by knew or should have known? What I'm saying is that if one of your managers or supervisors is aware that there is harassment or discrimination or harassment or discrimination claim, and they just decide that they're going to keep it to themselves or squash it or not escalate it, guess what? In the eyes of the state of California, since your manager that works for you knew about it, you as an organization should have known and should have done something about it, so your organization is liable for it. So again, knew or should have known. So what that means is have that open door policy, make sure your employees feel comfortable about reporting things, and make sure your managers and supervisors know what to do when they have a claim. Know that it's not something that they sit on or they squash or they try to make it go away or they're not bothered by. They know that if they have to, they address it, or if they have to, they escalate it to management or HR to do something about that. So, develop the policy, develop the complaint process, develop the investigation process, make sure everybody's aware of it and everybody knows what steps to take. Now, there are different things that could trigger an investigation, right? Again, if the employer knew or should have known that something was going on, that's going to mean we have to look into it right away. If you suspect something's going on, or if your manager suspects something's going on, that is something we should look into. If we observe the conduct, that's an easy one. You see harassment, discrimination going on, you address it, you investigate it, you do something about it. If you receive complaints from employees, whether they're formal, informal, anonymous, we're being put on notice. At this point, we know or should have known something's going on, so we have to act, right? Any administrative charges. In other words, this is where we get a letter from the state or a letter from a lawyer telling us that we're being sued. It's a little late, but at that point, we're being put on notice, so we should look into it. Any unexplained changes in the workplace, of course. If you have people that are being ostracized by others, or a lot of clickiness going on or something, you want to look into it, as well as any kind of persistent gossip or rumors. That's something else that we should look into to make sure that there's not any harassment, discrimination, or bullying going on in the workplace. So again, a lot of times I recommend if you have new managers or new supervisors, this is a pretty good slide for them to print up and maybe put in their office, or in their cubicle, just as a reminder that if any of these things are going on, that means they should look into it, or they should partner with HR immediately to address them. One, because it could be an issue, or two, because it could become an issue down the road. So you want to address them as soon as possible. All right, top three here. Let's move on to the top three ways to stay out of court. And the first one we have is making sure that you're using effective discipline and documentation. Very, very important. And if there's something that you would ask me as a new manager, as a new supervisor, what do you recommend? What's your best piece of advice? And I would say document, document, document. Document any kind of issue, document any kind of conversation, any kind of coaching, document everything, right? Reason for that is simple. If it's not documented, it didn't happen. If you find yourself where you have to defend an employment decision, why you wrote somebody up, why you terminated them, why their hours are cut, you find yourself in court, you want to be able to produce this documentation showing why it was done, or why there was a history of the problem that led up to this decision, whatever it is. Documentation is very important. Even if it's just a coaching conversation, right? You have an employee that comes in late all the time, and you pull them aside and tell them, hey, you know what? You need to start coming in on time, otherwise it could be an issue. Next time they come in, do it again, do it again. You said terminate them. You say, we talked about this. They could say, no, we didn't. Prove it. You don't have any proof. So even if it's just a simple coaching conversation, you want to make sure you have some kind of documentation. And documentation could be very simple, right? Here you see the steps for documentation. Number one, anytime we're documenting something, we're stating what the problem is. Why are we having this conversation? Why are we addressing this? Why are we talking about this? What is it causing it to happen? You being late is causing the rest of the team to either have a late start, or to have to pick up the work, or for us to not know if you're there and shift people around. Whatever it is, we're stating the consequences, right? Whenever we're giving coaching or documentation, our goal is not just to build a case to get rid of somebody. Our goal is to have that person correct that issue, right? If you're drawing somebody's attention to something they're doing wrong, the ultimate goal should be for them to correct that, to improve, to be better, and stop doing it. That's the whole purpose of us bringing it to their attention. We're not just doing that because we like to hear ourselves talk, or because we like to beat people down. We're doing it because we want them to correct the issue. So again, we're going to list the ways we can help them, give them resources. We're going to support them as long as they put in their own effort into correcting those issues. And finally, of course, we ask for you to get their signature. Now, this can be difficult sometimes, I know. Sometimes when you're writing an employee up, they'll say, nope, I'm not signing that. I don't agree. And the thought process there, I believe, is that if I don't sign it, it doesn't count. That's not a thing. So, if you find yourself in a situation where you're issuing a write-up or a coaching and the employee refuses to sign it, what you're going to do is, if you have a witness there with you, which we recommend for difficult conversations sometimes, you're going to have them sign it. You're going to sign it, and you're going to add a note that says employee refused to sign. Give the employee a copy, and keep the other copy for their file. That's perfectly fine. That counts, right? Just because the employee doesn't sign it doesn't mean that the document doesn't exist or it's not valid. In this case, all you're doing is you're verbally putting them on notice, giving them proof of what you said, and whether they agree with it or not. This is what the write-up is for. Now, for a more simple coaching, if you don't want to give it in writing because you think it'll make the person react negatively, or the person think that it's a write-up and you don't think it's that serious, what you can do is have the conversation with the person, coach them, and then follow up either with a text or a written, note, or an email. Hey, thanks for meeting with me today to discuss, your attendance and showing up late. As we mentioned, it's really important that you improve on that and you start showing up on time. If you have any questions, please give me a call. Sounds like a simple email, simple follow-up, but it goes far beyond that. What you've actually done is placed a timestamp on this conversation, historical context on it. It is now a living document that you can reference back to in case you have to escalate that corrective action in the future. So again, documentation is very, very important, and using effective discipline when we're addressing these issues. In other words, we're going to help, express that our goal is to for the employee to correct the issue, but also give them support in doing so. All right, top two. Here we go. And for number two, we have fire fast with no surprises. Remember I said in the beginning, I would like to say you want to hire slow and fire fast. Well, we're at that fire fast section, right? Now, what we mean by fire fast is when you decide you're going to terminate somebody, don't just kick them out the door and be done with it. What we mean by fire fast is when the decision's been made and you have all your ducks in a row, you have all the documentation you need, all the paperwork you need, you have the final check, you're not going to wait until, if it's Monday, you're not going to wait until Friday. You're not going to wait until next week or the end of the pay period because it's more convenient for payroll. Doing so puts you at risk, right? Once that decision is made and once you feel that you have enough, documentation, evidence to terminate this person, just do it. Get all your paperwork ready and do it because stalling or failure to do so, you know, there's a lot of things that can happen in the meantime. What if I decide, well, we really got to get rid of this person, but I'm going to wait till Friday after next for it to run with payroll. And between now and then, they slip, trip, and fall on the job. Something falls on them. Or they come to us and let us know, hey, you know what? I'm pregnant, or I have this health condition, or I'm, disabled, or what have you. Then, if we continue with that termination, we run the risk of it giving the appearance of being discriminatory or being retaliatory because of that protected condition. So again, it's time to end that relationship, have your paperwork in order, and just do it, right? Make sure the process is quick and fair. And honestly, a termination should not be a surprise for an employee. That's where setting those expectations from the beginning, having the onboarding be thorough and presenting all the expectations, policies, rules, procedures from the very beginning helps because at that point, if you have an employee that's been late, for 2 weeks and you've talked to them, they should know what the attendance policy is because you presented to them in the beginning. You counseled them along the way and they failed to correct that. So it comes down to termination. They're not able to say, well, I didn't know. Well, sure you knew. We talked about it at orientation. You got the handbook with the policy. I coached you 2 weeks ago and, gave you a documented, you know, warning about it. What do you mean you didn't know? We've talked about it all along the way, so it's not a surprise. It should never be a surprise. Employers should know the expectations and know the consequences for not meeting those expectations. Just as important too, it's time to terminate somebody. We want to make sure that we pay them correctly. Otherwise, we may be subject to waiting time penalties as well as interest, etc., etc. So the guidelines for final termination is if an employee quits voluntarily and gives you more than 72 hours notice, not 72 business hours, 72 regular hours notice, then their pay is due on their last day of work. So in other words, if I show up to work on Monday and say, hey, you know what? Thanks for the ride, but Friday's my last day, then at the end of the day on Friday, my employer should have my final check that includes all hours worked up until that Friday, as well as anything else due to me, whether it's vacation or anything like that, right? Or PTO. Okay. Now, if I quit and don't give 72 hours notice, so in other words, if I show up to work this morning and say, you know what? I'm tired of y'all, I'm out of here. Then the employer has 72 hours from that point to give me my final pay. And that's 72 regular hours, not 72 business hours. So if I come in on a Friday and say, you know what? I'm done. I quit. That's Friday to Saturday, Saturday to Sunday, Sunday to Monday. My final pay is due on that Monday, 72 hours later. Okay? Now, if you have the final check and the employee's not there, a lot of times employers call and say, hey, I mailed the final check, but never heard from them. Mailing that final check without authorization or without the employee requesting for us to mail that check and us having that documented puts us at risk because if we mail the check without the employee asking us to and it gets lost in the mail eaten by the dog, stolen by the neighbor, stolen by the roommate, whatever it is, we are on the hook for waiting time penalties. However, if the employee asks us in writing and confirms their address by email, by text, whatever it is, something that we can reproduce showing that they asked for us and confirm their email, and we send it to that email, if it gets lost, if it gets eaten, if it gets wet, whatever it is, we're not on the hook for those waiting time penalties as long as we can prove that we sent it, and that's we're sending it by registered mail, FedEx, UPS, something that has some kind of tracking is so handy. Now, if we're terminating somebody, that final pay, everything up until worked up until that day, is due upon termination. So when we tell a person, hey, I'm letting you go, you're fired, we're promoting you to unemployed, whatever terminology you want to use, once that action happens, you should have that check on hand ready to give to them. That final check should be a live check. We don't recommend you direct deposit. Again, because a lot of things can happen. You know, if you try to direct deposit that final check without authorization and their bank account is closed or their, ex-spouse has access to the bank account or it's, whatever. The tracking number's wrong, whatever it is, it could be problematic for you. So it should be a live check. If they insist on you direct depositing that check, give them a new direct deposit form so that they personally write the routing number, account number, sign it, and date it so they let you know that it was effective as of that time. The old direct deposit form is no longer valid. If they want you to direct deposit that final pay, have them fill out a new one. So, best practice for termination, of course, have a witness present. You may think it's not going to be problematic. If you think it's going to be a problematic termination, definitely have a witness. Even if you think it's going to be an easy one, have a witness there. You never know which way it's going to go, if they're going to claim anything down the road, right? If an employee is resigning or quitting, don't just take the verbal resignation. Have them put it in writing. You don't want them changing their mind, becoming a he said, she said, he said sort of thing, she said, whatever it is. Get that resignation in writing. If possible, conduct an exit interview. That way you get some feedback. You can correct any issues, identify any problems, any claims that maybe they were afraid to talk about. We can investigate them and have a termination checklist, right? We all miss stuff sometimes. So having a checklist is very, very helpful. All right. Thanks for hanging on for the countdown for us. We're down to the number one way to stay out of court, and that is to follow and keep your employee handbook updated. Very important, right? If you don't have a handbook, that's an interesting choice. I'll say that. We recommend having one because it's a great way to, one, show expectations to employees, present those expectations, and two, have them all in one place. So you don't have a bunch of different, policies floating around everywhere, right? That way you have one handbook, it's updated every year, it supersedes any previous policies or handbooks out there, so you always know it's the most up-to-date one, and everybody's reading out of the same book, following the same rules. So your handbook should confirm the at-will employment um, in the state of California. Make sure you have the right policies in there, the ones that are required by the state. Set those expectations. Again, you hear me talk about expectations for employees. You want to make sure that those are out there for employees to reference. Make sure that you have your harassment policy in there because it's going to be good defense. You could list your employee benefits in there, and of course, we talked about making sure that orientation sets the tone for your new hires. The handbook does the same thing. It should set a positive tone for your business, right? So make sure your handbook is not. I don't say make sure it's not boring because at the end of the day, it's a handbook. You know, we can only do so much with it, but make sure you're setting a positive tone, right? It's not there to hammer employees down. It's to show them the ins and outs of your business, what they can expect, what you expect of them, et cetera, et cetera. So there are some policies that are required to be included in your handbook, right? You want to have that at will statement as well as the right to revise. In other words, only you as the manager, CEO, business owner have the right to revise that handbook. Your foreman can't just decide they want to come up with a new policy and update it. Your administrative assistant can't decide they want a new policy and add it to it. All policies should be signed off by you as the business owner, you as a CEO, you as general manager, whatever it is. So make sure you have that in writing so employees know. You want to have your harassment prevention policy in there. You want to make sure you have the lactation accommodation policy in there. That's required by law, or lactation accommodation is, so you want to make sure that that's included in the handbook, as well as any required leaves. If you're a large employer, FMLA applies. If you're smaller, CFRA, pregnancy disability, applies to all employers, so make sure you have that, or I'm sorry, for all employers with 5 or more employees, make sure you have that in there, as well as paid sick leave. That applies to all employers. Make sure that's part of your handbook. And recommended policies we recommend you include timekeeping, meal and rest breaks, any other leaves of absence that apply to you, have those in there. If you offer vacation, that's a great place to have it so employers can refer to. Attendance policies, employee conduct, drug and alcohol free workplace. Put all those general policies in the handbook. Now, if you have any specific policies that are specific to just certain employees, certain groups, certain departments, you can have those separate, right? But all those general policies that apply to all your employees, put them all in one place, put them all in that handbook. That way your employees can refer to them. That way they know what's expected of them. That way they can't say, oh, we didn't know, right? Because yes, they did. You gave them the handbook on the first day, they acknowledge receiving it. It is all there. It's beneficial to them and it's beneficial to you. So with that, that concludes our top 10 ways to stay out of court. I thank you very much for being here, for listening to me, for wanting to stay out of court, wanting to improve your business and your business practices, right? I would like to remind you too that the Alameda County Workforce Development Board does partner with us for that complimentary HR hotline for you. So if you have any questions, whether it's about this presentation, any HR issue, if you have a situation you just want to talk about, give us a call. 888-202-5668 at no cost to you, Monday through Friday from 8 to 5. We are not here on some holidays, but if you call and leave a message, we'll get right back to you. If you're interested in membership with CEA, we do offer different levels of it. Everything from a monthly membership, if you want to just kick the tires and see what we're all about, all the way up to ultimate membership, all of those with different benefits. So take a look at those if you are interested. As Anna mentioned, we do want to hear from you what you thought of the presentation. What did you like? What did you not like? What would you like to hear about in the future? What topics are you interested in? Let us know. It's 5 quick questions. Answer all of them, answer some of them. But again, let us know what you thought. Just click on that QR code and let us know. And for those of you that are with us for continuing education, I do have some codes for you. For HRCI, we have 746439. That's 746439. And for SHRM, that's 26-YNE9Q. That's 26-You Never Expect 9 Questions. So, once again, thank you very much for joining us. I got Anna again. And with that, I'll open it up to you, Anna, if there's any final comments or final questions floating around out there. But otherwise, that is it for this presentation.
All right. Thank you so much, Eli. I love your little SHRM code anagrams, whatever they are. You know
Whatever.
what I mean.
Yeah.
But thank you for joining us live, for taking time out of your day. Thank you, Eli, for leading us through this rapid fire, but still very comprehensive training. And we look forward to seeing you all on the next training on August 12th. Hire right the first time. The link to sign up is in the chat. Cheers, everyone.